All right, everybody, let's finish up talking about structure, structural limits, and talking about the separation of powers. And we have basically one more area. We're talking about litigation involving the president. And I want to remind us that this is the Kickstarter that we've been using. Now, in terms of the Kickstarter, today's cases really deal with the interference idea, B2. And the courts in this case, they're not arrogating, they're not taking somebody else's power. Instead, they're doing something that they ordinarily do. They're issuing subpoenas to witnesses, they're presiding over civil suits against defendants. So there's also no doubt here about, that's all way of saying B1 is not an issue. And there's no doubt about B3. There's no doubt about institutional competence in this area. So again, what we're really focused on today for the rest of our cases is B2, interference. So let's go ahead and start. And we're going to have two cases, involving that man, President Nixon. So I'm just giving you something to look at while I talk for a second here. We are going to talk first about the difference between privilege and immunity. And this is going to come up in the cases. Privilege is an evidentiary rule. I'm not going to teach you the rules of evidence. You have a separate class for that. We need to know that privilege is an evidentiary rule, and it typically comes up in the context of whether a person needs to respond to a subpoena, either that they need to testify or that they need to provide documents. Now, if you can use a privilege like executive privilege, that's the one at issue today, that protects you from having to respond to the subpoena, from having to testify, or from having to provide documents. Now, let's leave privilege to the side for a minute. Second, there's immunity. Immunity is a rule about substance, excuse me. And regardless of whether or not you are protected by a privilege, immunity talks about whether or not you're going to face any legal liability. So maybe you have to testify, maybe you don't have to testify, that's privilege. But immunity is about whether or not you could face any legal liability. Could you be criminally charged, or could you face a civil case? Now, excuse me, where do the cases fit in today? I'm actually going to go back to this slide. So where do the cases fit in today? We're going to talk about three cases, and I want you to think about them in this way. First, we're going to talk about privilege. That's the Watergate tapes case, and it's about executive privilege against testifying. What is our conclusion there? Our conclusion is some qualified protection. So bucket number one for today, executive privilege against testifying. And the answer is there's some qualified protection. Bucket number two, our second case, the Fitzgerald case, that deals with immunity from civil damages. Immunity from civil damages for actions that are based on conduct while in office, while the president's in office. What do we say for bucket number two? Absolute protection. So again, you're the president, you face a civil suit for actions that you took while you're the president that relate to your official duties, you're absolutely immune. That's the punchline. I'm giving you the kind of buckets, and then we're going to dive into the details here. Last bucket, bucket number three, immunity from civil damages while you're in office, but the suit is based on conduct that you took out of office. That's the President Clinton situation where he's sued by Paula Jones, and it's based on actions that he took or didn't take before he was president. What is the rule in that case? No protection, no immunity. So those are our three buckets. If you want to make a chart, please make a chart, but that's where we're going today. So we're going to start with the tapes case, excuse me. Now, what's going on in this case? There's a special prosecutor, and he wants audio tapes of conversations recorded by former President Nixon in the Oval Office. He wants the Oval Office tapes. This is partly a result of a grand jury returning indictments against some of former President Nixon's advisors because of their participation in the Watergate affair. Now, Nixon says, no, I don't have to respond to the subpoena. I'm immune because of this thing called executive privilege. And again, executive privilege is an evidentiary privilege, and it would give the president and maybe some of his close advisors the right to withhold information from other government branches. What does that mean? What does the right to withhold information from other government branches really mean? It means that you don't need to respond to a congressionally issued subpoena or a court issued subpoena. That's basically what it means. You don't have to respond to the other branches. The other branches being, again, Congress issues a subpoena, or the judiciary, there's the court issued subpoena. Now, there are two big reasons for this privilege. The first is basically to allow presidents to have free conversations with their advisors to get the benefit of all of the advice and expertise that they can without worrying that everything that they're going to say could potentially be subject to a congressional subpoena or a court issued subpoena. So the first is this idea of preserving confidential communications within the executive branch. The second, and maybe more obvious reason to support the executive privilege, is this idea of securing the national interest, basically, again, national security issues. So what happens in this case? In this case, the court agrees that there is this thing called executive privilege, but that it is not absolute. So there is a thing called executive privilege. It's not absolute, it's qualified, and it does not cover President Nixon in this particular case. So the court phrases this, and others phrase this sometimes as saying that his right to assert executive privilege is not entirely immune from judicial review. What does that mean? It means judges have a role here because it's not an absolute privilege. That's what that means in plain English. Now, what does the court say here? That we don't need an absolute rule here. We don't need absolute immunity. It's not required by separation of powers, and it's not required by some kind of generalized need for confidentiality of high-level conversations. Now, the Supreme Court, again, part of the key here is they admit, yes, there is this thing called executive privilege. The purpose two purposes: protect confidential communications in the upper levels of the executive branch, to protect national security. But that's on one side. They say there's a balance here. And the balance is that sometimes you have to allow cases either against or involving the president to continue. And if there was absolute executive privilege, it would really thwart those cases. So again, the court here is creating a balance. Like on the one side, there are those two reasons for executive privilege. On the other side, there's reasons that we want the judicial system to be able to function. And if we say that the president can just basically throw executive privilege as a blanket of protection around himself and maybe his advisors, that would prevent some cases and investigations from being able to move forward. So the conclusion is that Nixon has to comply with the subpoena. He has to produce the Oval Office tapes, and he resigns shortly after the release of the tapes. Now, some more specifics here. That's the overview. Let's talk about a few more specifics. The case that you read is really framed in terms of, as what we've been talking about, a president's obligation to respond to a subpoena issued to the president as a witness in a grand jury proceeding. And we know that courts can issue subpoenas, but what I want to highlight here, something I mentioned before, is that Congress can also issue subpoenas. And again, I'm highlighting this because just a few moments ago, I said, this is about the president being able to protect information from the other branches. So one branch, obviously, the judicial branch, another branch, the legislative branch, Congress. So let's talk about Congress's power here for a moment. What's the source of Congress's power? What's the enumerated power that would allow Congress to issue subpoenas for testimony? Well, the necessary and proper clause. Congress's ability to make laws on various topics is constitutionally acceptable. That is a constitutionally acceptable end. Congress can make laws, but how can it achieve that end? Meaning, what's the means that's properly tailored to achieve that end? Well, one means is allowing Congress to gather information, to be able to get information from people, that's testimony, get documents, in order to make good laws, that they need information before they can craft good policy. And of course, let's not ignore the background here. What's happening in the background? Everybody knows that the committees of Congress are actively investigating President Nixon, former President Nixon, to decide if he should be impeached or not. Now, so we've been talking about the fact that there are court-issued subpoenas, there are congressionally issued subpoenas. Should a president's claim of executive privilege be any different when he's responding to either a congressionally issued subpoena or a court-issued subpoena? And the answer is probably not. The separation of powers concern is basically the same, that another branch, either the judiciary or the legislative, that they're inflicting an injury on the executive branch. But there are a couple of reasons to think that maybe actually congressionally issued subpoenas stand on even firmer grounds. Now, Congress is pursuing an enumerated power. So Congress has like a power that's grounded in the text of the Constitution, and that gives them the power to act. Whereas when it comes to court-issued subpoenas, there was some common law that actually talked about history of immunity from the judicial process. Now, in this case, the court didn't have to rule on kind of the validity or propriety of congressional subpoenas. But for our purposes, what I want us to basically recognize here is that the answer to a claim of executive privilege is likely to be the same, whether we're dealing with a congressionally issued subpoena or a court-issued subpoena. Now, let's move on to a slightly different topic, which is thinking through some arguments for and against having executive privilege. Again, what are some arguments for and against having executive privilege? Excuse me. Let's think about arguments for having no executive privilege whatsoever. Well, one is no one is above the law. Another is that full fact-finding in criminal cases is really important. And that can only happen, sorry about that, that can only happen if the president has to comply with subpoenas. So that's really the argument here for saying, well, maybe there should just be no privilege. Another argument for saying there should be no privilege, if Congress wanted there to be executive privilege, then why not create a law? Why not legislate for that? So those are three reasons that we should talk about or think about for having no privilege. What about arguments for an absolute privilege? Not just having a privilege, but having it be absolute. One argument, the president needs privilege in order to function. The president shouldn't be looking over his shoulder all the time, worried about subpoenas. Number two, an absolute privilege avoids the problem of judicial line drawing. That just means in plain English, sometimes the privilege applies, sometimes it doesn't. Do we really want judges involved in determining when it applies and when it doesn't? Third, without an absolute privilege, then you might have politically motivated subpoenas, and the subpoenas would be used as a weapon against the president. Now, last thing, what about arguments for a qualified privilege? the arguments here are it allows for basically a case-by-case approach to privilege. And so it'll apply when we need it to, when the balance indicates that it should, and it won't when the balance really flips in the other way. Another reason for having a qualified privilege, all of these situations, the facts are going to vary pretty dramatically. And so maybe a case-by-case rule, a qualified rule, is really the best way to approach this particular situation. And number three, courts really often prefer this. They don't mind being involved a lot of the time. They prefer this middle path. And so again, as we saw in this case that we've been talking about, that's the path that the court takes. They take this middle path of a qualified privilege. I'm going to stop for 1 second. All right, we're back. So we were moving into talking about how a court should decide a claim of executive privilege. We've decided that the privilege exists. We've decided that it should be qualified. And now the question is, how do we go about deciding when it applies and when it doesn't? And this is really part 3C of the opinion. And what the court says is we have to engage in another weighing process. And on the one hand, we have how much do we need the testimony? What's the value of the testimony? On the other hand, we have what's the value of the privilege? And so what are we looking for in terms of the value of the testimony? The court tells us we're looking for the demonstrated specific need for evidence in a pending criminal trial. The value of the privilege must be shown by what? Something other than, the court tells us, just a generalized interest in confidentiality. So you need to be kind of specific when you're asserting this privilege. Now, the Supreme Court says there's actually a presumption in favor of the privilege applying, but as you just heard in terms of me giving the test, it kind of reads like there's a presumption against the privilege, because in actuality, the president has to come forward and say, here are really specific reasons beyond just generally I need confidentiality in order for the privilege to apply. Now, next question I want us to think about, should the ability of the president to refuse a subpoena in a criminal case be different under different circumstances? Again, I'm not going to give specific answers here. I just want us to kind of think through why this is best as a case-by-case determination. Well, maybe one difference is, what if it's the president who is the target of a criminal investigation versus somebody else around the president who's the target of a criminal investigation, but you just want information from the president? The worry here is that when the president is the subject of a criminal, there'll be a really intense motivation for the president to use the claim as trying to protect himself, obviously, that there's this fear of self-dealing. And so there's an idea that maybe when the president is the one who's the subject of the investigation, maybe we should be a little bit more skeptical of assertions of the privilege, meaning we should be less likely to be willing to use the privilege. Some other things for us to just think about a little bit in the back of our head when it comes to executive privilege. Should it matter what information is covered by the subpoena? If it's domestic policy, foreign policy, election strategy, are there certain things that we want to keep private and we're more concerned with keeping private than others? And the answer is yes, that's exactly what the court will look at. Okay, let's finish up talking about suits against the president. And we're moving on now from executive privilege, and we're talking about immunity from damages in civil suits. Again, we're talking about the president being sued. The president is a defendant, and the president is either immune or not immune, or immune part of the time, or it depends on the facts. So let's start with this case, Nixon versus Fitzgerald. A little bit of background here. It's 1968. Fitzgerald is a civilian analyst with the Air Force, and he testifies before a congressional committee. And he basically says there's a whole lot of problems with the production of certain planes. He says the production is inefficient, they cost too much, and a year later, he's fired. And President Nixon takes responsibility for the firing. That is important for us. It's important for us that President Nixon says, yes, this is something that I did as president, because as we're going to see, part of the dividing line here is between the president acting as a private individual, if he ever can, and the president acting as the president in his official capacity or his official duties. So Fitzgerald sues Nixon essentially for unlawfully firing him. And so there's a little bit of background that's not really key for our case. The Civil Service Commission says the dismissal was unjust. Again, Fitzgerald basically sues Nixon for wrongful termination. And the case goes up to the court about whether or not Nixon is immune from civil suit. And the court says he is. In a 5-4 decision, the court says the president is absolutely immune. Again, absolute immunity from liability in a civil suit when the suit is based on official acts. Again, when the suit is based on official acts. Why does that matter? Because when the president is acting as the president, as head of the executive branch, then we're worried when it comes to separation of powers issues that he should not face liability from, for instance, the judicial branch. And there's a little bit more there too, in terms of worrying about creating a chilling effect on the president that I'll talk about more in a minute. So again, we're really trying to focus on this difference between suing a president based on official acts and suing a president in his individual capacity. Here, because Nixon is sued in his official capacity, it means that he has absolute immunity according to the court. Now, this means that the judicial system really cannot exercise jurisdiction over this case, that there can't be any liability imposed. And so I want to, that's kind of what President Nixon wanted in the tapes decision. So I want to talk about that difference for a moment. So what's happening here is, in this case, Nixon is saying, I can't face any damages based on this suit. I was acting as president and I should be able to have absolute immunity. And the court says yes. But what does the court say in this case? In US versus Nixon, the Watergate tapes case, the court says no absolute privilege, right? That executive privilege is limited because we want the judicial system to be able to exercise control in certain circumstances. We want basically cases involving an investigation of the president or criminal cases. We want those to be able to move forward in certain circumstances, and they can't if you can't get any evidence from the president. If the president just says, look, I'm not giving you any documents, I'm not giving you any testimony. So I just want to be clear on the kind of difference between the cases here. Again, the US versus Nixon involves executive privilege, and the court says the privilege exists, but it's limited. And Nixon versus Fitzgerald involves immunity in a civil case, and the court says there is immunity, and in fact, it is absolute. And Nixon, of course, would have loved that decision in the Watergate's tape case as well, but he didn't get it. Now, let's talk about the dissent in Fitzgerald for a minute. The dissent here doesn't really quibble with like the overarching theory, but they don't think it should apply to every action. They don't think there should be absolute immunity in every action taken in the course of presidential duties. They basically want there to be immunity, but for it to be narrower. And they say there should be immunity, maybe just dealing with the president's core functions, not all his functions. I'll say that's kind of tricky here, because who wants to parse between what the president's core functions are and what are kind of the outer bounds of the president's duties? And so the majority takes more of a bright line approach. The majority is just saying here, you know what, you're sued, it's a civil suit, it's based on actions that you undertook as president, therefore official acts, there's absolute immunity, period. The dissent would rather kind of parse and make that absolute immunity a smaller category. Okay, I want to talk about something else as a result of this decision by the court that there's absolute immunity in some cases for the president. Now, and basically the question I want to ask is, does this mean that the president can do anything? And the answer is no. And the reason I'm asking this is there's a famous video, there's a famous interview. It's a 1977 television interview. The British journalist David Frost famously asked former President Nixon, excuse me, can national security justify something like the government illegally wiretapping? And that's, of course, part of what happened in Watergate. Nixon's response is, when the president does it, it's not illegal. When the president does it, it's not illegal. And so our question is, in light of Nixon versus Fitzgerald and this absolute immunity, is Nixon right? And the answer is no, of course he's not right. And in part because there's a difference between you won't face liability versus what you did is legal. There's other differences here too. So difference number one, just because you won't face civil penalties doesn't mean what you did is legal. Number two, there are still other repercussions. So you could still, as president, face a criminal investigation, and you could still, as president, potentially face impeachment. So it's just way too broad to say that because the president does it, it's legal. That's not right. Now, the next thing that I just wanted to close with, again, is, are these two cases consistent? And I kind of talked about this a little bit a few moments ago. I would say on the level of factual holdings, yes, they're consistent. One involves the president as a witness. That's this case. And the court says no executive privilege there. Executive privilege exists, but it's qualified and it doesn't cover President Nixon. The other involves the president as a defendant. And the court says, in this different factual scenario, absolute immunity. So again, on the level of facts, you can say they're so different that the two decisions are consistent. On the level of policy, I think what we really need to ask is, basically, does one say, this one, no person is above the law? And does another one, this one, say, yeah, the president actually is above the law? I think there is a little bit of a policy inconsistency there. Now, one other thing to think about, as we continue here, Nixon versus Fitzgerald, again, is premised on this idea that the president has absolute immunity for official acts. And I mentioned this a little bit a moment ago, but it's really increasingly difficult to see when the president takes an action, undertakes an activity, and it's not included in the president's official acts. Again, it's just going to be very private things that fall into that category. And again, we can talk more in person about some newsier cases that are happening right now. So that, I think, brings us to the next case. Again, just looking at the slide, where are we? This just summarizes what we talked about. There's absolute immunity from damages, meaning in a civil case, based on the president being sued for his official acts. Okay, here we go, our last case. Again, sticking with immunity, the difference here, the difference between Clinton versus Jones and Nixon versus Fitzgerald is President Clinton is sued while he's president, but for actions based on things he did before or didn't do before he was president. So again, Nixon versus Fitzgerald, the actions at issue in the case, the firing, happened while Nixon was president. Clinton versus Jones, the actions here happened before Clinton was president. And here, the punchline, as we've already said, is that the president is not immune, that there's no immunity. So Jones can sue Clinton. So let's talk about the case a little bit more. Paula Jones is a former Arkansas state employee. She alleges that then Arkansas Governor Bill Clinton made unwanted sexual advances to her, that she rebuffed him, and she was retaliated against. Jones sues Clinton, and obviously this is a civil case, and the court, as I said, concludes this suit can go forward here. The suit can go forward because this is not based on what his official acts as president. This is based on actions he undertook before he was president. And that's the key here. Now, what's happening policy-wise in these two cases? When it comes to Nixon versus Fitzgerald, what we're really worried about, again, is that there will be so many suits, excuse me, there'll be so many suits against the president based on his official conduct that he won't want to engage in any official conduct. That basically, if every time he makes a decision, he can be sued, he'll just make fewer decisions. The same fear is not present here when it comes to Clinton versus Jones, because he's being sued based on actions he took before he was president. So we're not worried that President Clinton is going to be concerned that every time he undertakes an official act that he might be sued. Having said that, there is a similarity between the two. So one fear is we're chilling the president in terms of the president undertaking official duties. And that's, again, really what Nixon versus Fitzgerald largely is about. We want the president to be able to act without fear of constant civil suits. Clinton versus Jones says, yeah, the president can act without fear of constant civil suits because this is based on actions that the president took way before he was president. So that's the difference. What's the similarity? The similarity is that in both cases, we are concerned that being a defendant is going to take a lot of time away from the president. So in Nixon versus Fitzgerald, what we conclude here is that the president is not going to be a defendant. And part of the reason is it would just take a lot of his time and resources, and it would be distracting. In Clinton versus Jones, we're basically comfortable with saying, well, okay, but the president is going to have to act as a defendant and respond to this case. And so even though it might take a lot of the president's time and resources, the majority says the case can go ahead. Now, I want to mention that the idea that we talked about in the beginning, this idea of a chilling effect on the president, while it is different between the two cases, you can imagine that as a result of Clinton versus Jones, there was the worry at the time that, well, so many people could sue the president for actions that he undertook before he was president that it could basically paralyze him into inaction. We now know that that fear didn't quite bear out. There are fears related to congressional subpoenas that we can talk about more at another time. Now, just a few more notes on Clinton versus Jones. And I really want to finish up by talking about the stay here in this case. And this is just really a summary of the Clinton versus Jones case. Again, we're focused on unofficial acts. So let's stay with this. It's a slightly more interesting slide. Let's talk first generally about what would be the harm in just waiting for this case to proceed until the president leaves office? So what would be the harm in the trial court saying, you know what, this case can go forward, but not until the president's term is over? And so let's think about the harms of a stay, meaning, pausing the trial court. Well, one is evidence could become stale. Two, justice delayed is justice denied. Three, it gives the impression that the president is above the law. Now, what about the harms of allowing the case to continue, meaning denying the stay? Well, something we just talked about, interference with presidential duties. It's going to take the president a lot of time to defend against this case. And again, it increases the likelihood that there could be more cases and potentially just frivolous cases. Similar question, but a new question. Given that trial courts have a lot of discretion over their scheduling, why does the Supreme Court here say that the trial court's stay was an abuse of discretion? And this is covered in part 7 of the opinion. I want to point out a couple of things. So the majority says trial courts have their customary discretion over their own scheduling. But its reasons for finding that granting the stay here in Jones was an abuse of discretion, they seem to apply pretty broadly. And what I want to point out is they seem to apply in virtually all suits against the president. And based on the majority's reasoning, what we're saying here is that it's not clear what facts would ever justify a trial court granting of a stay in a similar situation. And that's part of what Breyer is concerned about in his concurrence. Now, the stated reasons here for why the stay is improper seem to be these. So let's go over the reasons that the majority gives for why the trial court granting of the stay, pausing the case, are improper. One, delay is bad for the plaintiff. But again, that's always going to be the case. Two, the court says the stay was premature because the trial judge should have waited to see basically how discovery played out before staying the trial. Now, maybe the problem, we could say, maybe the problem is that the trial court judge just didn't stay enough because discovery was allowed to continue, but the trial was stayed. And so maybe that just seems kind of pointless, especially again, since in the vast majority of cases, the major purpose, the major function of a trial date is just to force a settlement, not to actually hold a trial. So in order to stay both discovery and trial, maybe wouldn't be subject to the same objection here about a trial only stay. Again, part of the majority's problem here is that the stay was just too early because the court allowed for discovery to continue, but they stayed the trial date. Let's think about another reason that the stay seems improper. So we've talked about two. The third, the president needs to make a precise showing about the need for a stay, rather than just arguing in generalities that as a general matter, he's entitled to a stay. I think that's the crux of the matter here. I think that's the main thing that's happening here. And again, that language should sound similar to the language we discussed in Nixon about the president having to give specific reasons, not just generalities. So in other words, I think what's happening here is it might not have been an abuse of discretion to grant a stay in this case, but it was an abuse of discretion to grant it on the arguments presented, meaning that the president didn't present enough arguments to justify the stay. So that is really what I want you to know about Clinton versus Jones. Again, what is our summary here for these cases? Well, our summary here is that when it comes to executive privilege, there is executive privilege, but it's limited. It's a qualified privilege. When it comes to civil suits against the president for actions undertaken based on official duties, there is absolute immunity. When it comes to civil suits undertaken that are against, civil suits against the president that are undertaken, that are based on actions undertaken before the president was president, then there is no immunity. And so those are our three buckets, and that's where I am going to leave it for now.